Welcome to the Supreme Court of the United Kingdom, where we are today embarking on the second day of the hearing of the appeal in the case of AB and the Secretary of State for Justice. The issue in the appeal, put very shortly, is whether the treatment of the appellant when he was a 15-year-old boy detained in Feltham Young Offenders Institution breached the prohibition on inhuman and degrading treatment in Article 3 of the European Convention on Human Rights. I should also say that his name has been withheld in these proceedings. He's described as AB. That's in order to protect his health and safety. And there is an order prohibiting the publication of information which would be liable to lead to his identification or that of his family. At the moment, we're hearing the submissions on behalf of the Secretary of State, presented by Sir James Eadie, Queen's Counsel. So I'll turn now to Sir James and invite him to continue.
My Lords, good morning. Yesterday, as you will recall, I was finishing up on the fourth of the propositions, as well established under the jurisprudence of the European Court of Human Rights, namely that age can be a relevant factor. And I cited the three cases I did yesterday that you will recall: Uyed in Belgium, Majelka in Belgium, and Guveç in Turkey. And just to finish that point, there is no suggestion in that case law that this feature of being a minor in some way obviates the basic approach of intensely examining the facts and all the relevant facts of the case. The approach of the European Court is to examine all of the circumstances rather than applying a hard-edged set of rules or presumptions. And it is correct in principle, we submit, that that is the approach, given the breadth of the variety of factual circumstances that might arise in any particular circumstances, and also given the extreme seriousness of a finding of violation of Article 3, that right sitting at the very top of the ECHR hierarchy. So it is of course right that the European Court and this court and the courts below could have regard to the fact that someone is a child or a minor, and they do so especially because being a child or a minor, particularly a child or a minor in detention, and particularly being a child or a minor in detention with mental health difficulties, renders them particularly vulnerable. No one on this side of the court is denying the relevance of that. And indeed, some features, including, for example, education, apply particularly and perhaps only to children. But that is not the debate here. The question is not whether children are special for any or all of those reasons. They are. That is common ground. The question is whether there is a hard-edged principle that if a child is segregated in a way which conforms to one or other of the ways in which solitary confinement might be defined for a certain period, that is automatically a breach of Article 3, so as to obviate taking into account all of the other circumstances that might bear on the seriousness of the treatment in the particular and individual case. And when Strasbourg has gone into the territory, as it were, of hard-edged examples, one can see the sheer extremity of the things that they were dealing with. So if one takes some examples, perhaps from the case law, perhaps the only real examples from the case law where they've applied something that approximates to that sort of approach, they have involved the drawing of the sort of distinctions that you saw being drawn in the Ahmad case, namely the distinction between complete sensory isolation and partial isolation or relative isolation of the kind that you saw analysed in detail in Ramirez Sanchez, or they have involved indefinite detention as compared to, for example, the 8 years in Ramirez Sanchez and the various other periods that were identified in the case law considered in that case. Or perhaps you have a serious minimum, a real minimum in relation to the size of the cell. They got close to it in Mersich, as you will recall, where cell sizes of less than 3 square meters were considered inherently extremely problematic. But you do not find that approach generally tripped, as it were, by the simple fact of it being a child in detention and something which could be defined as solitary confinement coupled with it. So that's what we say about the Strasbourg case law and the basic Strasbourg approach. I was going to turn then to the, at least in this court over recent years, the relatively well-trodden territory, so I'll take it relatively quickly, of the principled approach to the use of international materials. And I start with the UNCRC, which is the principal treaty relied upon. Again, the court has considered that treaty on a number of different occasions in the recent past, and it is clear and accepted that provisions of the UNCRC may be relevant in interpreting the meaning of the articles in the ECHR. That's been emphasized by Strasbourg in cases, I think, starting with De Meer and moving on to Neulinger and Austria. The clearest acknowledgement, perhaps, of the relevant principle is set out in Lord Reid's judgment in the SG case at paragraph 83, acknowledging the potential relevance of the treaty provisions to the interpretation of the ECHR articles. That's paragraph 83 of SG at page 1443. But we emphasize 4 points in relation to that interpretive rule or principle or exercise. The first is that the UNCRC, as Lord Reid in that passage acknowledges, is a treaty which is unincorporated. That's the starting point, which is well established. And that means that the treaty provisions that you are considering are not, unlike the ECHR, provisions that are scheduled to the Human Rights Act. They are not part of domestic law, and they give rise to no rights or obligations under domestic law. And it follows, as Lord Reid pointed out at paragraph 82 of SG 1442, that exactly the same applies, perhaps a fortiori, to the comments of any committee commenting on the provisions of the other treaty, namely the UNCRC, and I'll come back to those. Perhaps the real punchline of the fact that this is an unincorporated treaty is not to deny its potential relevance to the interpretation of ECHR articles, and this is the second point, but to render it illegitimate through the door-marked interpretation of the ECHR, simply or in substance to treat another set of obligations in an unincorporated treaty as if they were incorporated. There is, if you will, a distinction between use as interpretation and, in substance, incorporation of the other unincorporated treaty. And the effect of the appellant's argument comes perilously close, we submit, to bringing the entire UNCRC and all of its associated guidance or commentary into domestic law through what would be a very large and very open backdoor. And that risk, in constitutional terms, has also been the subject of considerable authority in this court, going back as far as Brind, where precisely that backdoor incorporation vice formed the foundation and basis for the House of Lords judgment in that case. But the lesser vice is equally true, if you will. Just because a treaty set out the detail, or more detail in a particular area than the broader words used in the ECHR, simply treating that detail as though it was incorporated into the ECHR through a process of, quote, interpretation is particularly difficult, we submit. The third point about the exercise of interpretation is that the principled foundation for and permissibility of this reliance on other treaties is to be found in Article 31(3)(c) of the Vienna Convention on the Law of Treaties. And at its heart, as has been pointed out in some of the cases, the aim is to avoid conflict or fragmentation between the ECHR and or other international treaties. So if the developed principles or provisions of another treaty do not create or lead to that risk, the force of the reliance on them as a process of interpretation thoroughly diminishes, we submit. The fourth thing to bear in mind, and it's perhaps to state the obvious, is that the principle here is one of interpretation. You're relying on the provisions of the other treaty by way of interpreting a provision in the ECHR. And what that obvious statement emphasizes or brings with it is that the rule in the other convention must be a relevant rule. You need to be very clear that the provision in question is indeed what you are dealing with when you're considering an issue under the ECHR, both as to subject matter and ensuring that you are dealing with something which is akin to a rule. And I emphasize that latter point because that might be very difficult if the basic principle under the ECHR is already established, and it is a principle which effectively invites courts and the ECHR, the European Court of Human Rights, to look at all the facts. So it's got to be a relevant rule in both of those senses. It's also got to add materially to the ECHR jurisprudence so as to inform the interpretation. Of course, interpretation can be simply looking at a word which has an ambiguous meaning in the other treaty, the ECHR, and giving it some effect. I don't seek to restrict interpretation with quite that rigor, but it nevertheless must inform the interpretation of the particular provision, however broadly or generally expressed in the ECHR. And perhaps finally, even if all of those things are made out, there is, under the permission to look at the other treaty by way of interpretation, only a requirement to take it into account. It is entirely open to the, under the convention jurisprudence, to consider the other provision and for the European Court to decide that it's going to take its own view. It doesn't, by way of interpretation, treat the provisions of the other treaty, detailed or otherwise, as binding. And of course, underpinning all of these points is the distinction between interpretation and application, of which the present context, it might be thought, provides a pretty good example. Particularly because the nature of the obligations and rights to which the ECHR gives rise are very clearly established, and so is the approach to be followed in determining whether those general principles and that framework leads to a breach. When you apply the basic principles that I've already been through, that the ECHR case law establishes. So those we submit are the principal points in relation to the UNCRC and any attempt to rely upon the detail. I'll come to the application in a moment. I'm simply dealing with the principles for the time being. That's the UNCRC. There is then what is compendiously described as soft international law. And perhaps three short points can be made on the principled approach in relation to soft international law. The first one is to submit that a very much more cautious approach is required before taking into account or attaching real weight to that type of law. Things like general comments are nothing like treaty obligations. Their authority, even under international law, is slight. And I take that word, slight, from Lord Wilson in AB at paragraph 35, page 1098. Citing for that purpose, I don't invite you to turn it up because the references are to support the word and the proposition, citing Lord Bingham in Jones at paragraph 23, that's Lord Bingham at paragraph 23, which if you want it in the raw is at page 1316 in the electronic bundle. So they're nothing like treaty obligations, nor do they provide evidence of anything like common internationally accepted values. They are rather more or less controversial views of a body charged with opining and offering views on a different treaty. And of course, different bodies under different treaties may apply different approaches to similar or the same language. The point of that being that states do not and cannot be taken to have signed up to an approach which in effect involves looking for the highest common denominator in terms of commentary, even on similar language. And both of those aspects are reinforced here, given the limited functions of the committee making the general comments under the UNCRC, because that's what we've been focusing on. We've set out the position in international law in terms of how that body operates in our case at paragraph 62, the core point being that that body has no power to give binding interpretations, even of the UNCRC. It simply makes general comments and recommendations. So as Lord Wilson pointed out, his point about slight value in terms of interpretation operates a fortiori, whereas he put it, the commentary is not even binding in international law. So although it is true that some of the case law on the general comments under the UNCRC have referred to those comments as the most authoritative commentary, it's to be recognised that authoritative, as we all agree, is not referring to anything that is binding, even on the international plane, as Lord Hughes noted at 152 of SG, page 1463. I think the reference to most authoritative is Lord Carnwath in the same case at 105, page 1450, but not merely not binding, but simply indicating that that's the body that comments on that particular treaty. It isn't ascribing any particular force under international law, and it isn't describing something which should be taken as authoritative for the purpose of the ECHR right. And what the appellant is here doing is to seek to ascribe particular and very heavy weight to these soft aspects, in particular this commentary, in effect as driving a conclusion that Article 3, applying the well-established Strasbourg case law, is violated. That goes well beyond taking them into account, and they need to go there because the Court of Appeal plainly did take into account all of these, and they introduced, as we will see in due course, various qualifications and reservations going to the weight that is truly to be ascribed to that commentary. But that's not the game that my learned friend is engaged in at all. He wants to say, here is commentary that you can in effect transpose into the ECHR arena that tells you that there is a hard rule under the ECHR, or that Strasbourg would impose a hard rule when Strasbourg has done nothing of the kind, because its approach is intensely fact-specific. So that's the first point about greater caution in relation to soft international law, even when applying by way of interpretation some of the detailed provisions in another treaty on related subject matter. Secondly, the case law indicates that the courts have shown themselves, including in Strasbourg, to be very conscious of the need to be cautious, unless there is truly something like a common international standard, which the soft law is reflecting. See, and I don't invite you to turn them up now, the cases we cite in our case at paragraphs 50 and 51. And I was thinking, for the purpose of this appeal, how one determines that issue. I'm not sure there's much guidance in the case law about how you determine whether you've reached a place where there's a common international standard or something equivalent to it. That there is such a requirement, or that you afford real weight if you get to that place of commonality, is clear from Demir and Turkey, paragraph 86, page 2516, where they described the concept as being, quote, common ground in modern societies. But trying to think through what you would need to get there are perhaps a couple of analogies that might be put on the table, at least for consideration by the court. Neither of them exact, perhaps, but one of them is the formation of customary international law, whereas alongside the relevant rule needing to be treated as binding as a matter of international law and recognized as creating a binding rule by states, you need at least sufficiently broad acceptance of the existence of the principle. Something like that first or that latter part at least may underpin common ground in modern societies, and it may do so in principle, because you need that degree of commonality before the thing has force as a point of interpretation bearing on a particular treaty like the ECHR. The other analogy which occurred to me was you very often have, particularly in the context of positive obligations under the ECHR, and it bears particularly on the breadth of the margin that is afforded to states, the idea as to whether or not the Council of Europe states have all sufficiently signed up to a particular idea or concept. And it may be that that was the thought that my Lord Reid had in mind yesterday when referring to things like the CPT as Council of Europe instruments or issues.
Yes, that's exactly what I had in mind. The Committee of Ministers' recommendations are obviously issued by one of the institutions of the Council of Europe. The Court is another of those institutions, and we're all familiar with the fact that they pay regard to what the Committee of Ministers recommend. It seems to me its relevance is probably in as indicating a consensus within the Council of Europe as to what is appropriate in this field.
My Lord, yes. I mean, I'm going to come to the CPT and the recommendations in due course, but that at the moment I'm just on a consensus about something.
Yes.
There'll be a question about what is the consensus about? Is it a consensus in relation to future action? Is it a consensus that people need to think about these things? Or is it a consensus that there is, in fact, already a rule operating in effect as something hard-edged, so that if you do not conform to it, ipso facto, there will be a breach of Article 3, and there's a pretty big difference between the one and the other. But at the moment, consensus and that idea of things that are maybe said to be at least to have a degree of commonality, either across states or particularly in the Council of Europe, is what's needed. So you need something like that, and it needs to be on the very point in question. If you're asserting a hard age rule already exists under Article 3, and to be clearly accepted as a current norm, one wants to use that language, not merely a developmental aspiration. The third of the points that I wanted to emphasize in relation to soft international law I've touched on already, which is that even if there is some degree of consensus of that kind, or something approximating to a common international standard, the furthest the ECHR jurisprudence has gone is that it takes into account a broad range of international materials and views, and then takes its own view. And I put it that way deliberately because what Mr. Squires appeared to be suggesting was that there needed to be something, if you establish a soft or even a slightly harder international rule, there needed to be something which said, well, I disagree with the intrinsic analysis of a committee on the particular convention that it is considering. My respectful submission is that that is nothing like the approach that the European Court has taken. What you consistently see in the Strasbourg judgments, and you can go back to, I'm going to take you to Merzic in a moment, you go back to Boyd for the same thing, when we come to the recommendations, you'll recall Lord Reid raised yesterday paras 52 and 53 of Boyd, which referred to those recommendations. That exemplifies the Strasbourg approach. What they tend to do is to have a pretty large section of the judgment which summarizes the totality of all the international material they can lay their hands on, without, to some degree, differentiating between status and whether it's precisely on the point or not. Or it all goes into that section. And then when you get to the actual analysis part, the court's assessment part, or the dispositive part of the judgment, you sometimes, as indeed in Boyd, in relation to the recommendations from the Council of Europe, reflecting whatever consensus they reflected, little reference or simply a reference back as confirming a view that the court had already reached on its own. Merzic in Croatia is not a bad and quite an interesting example in relation to that. Can I invite you to take it up? And the page I want in the electronic bundle is 1884. Because it gives you an example of this approach in action, and Strasbourg considering, here it happens to be the CPT, so it's relevant for that same reason that Lord Reid was just referring to a minute ago. But you see what they do when they get to their judgment, 111 to 113, if I can just invite you to read those paragraphs. And those are important paragraphs in the light of the argument that you are confronted with on behalf of the appellants. Because when the court here refers to the concept or idea of a decisive argument, that is directly to be equated with Mr. Squire's suggestion that there is a hard age rule. In his case, it's different because it's triggered by a child plus, it appears to be triggered by child plus a certain number of hours in the cell per day, leaving all other factors out of account. He says, well, that's the decisive argument. That's a hard age rule, per se breach of Article 3. And these paragraphs contain the destruction of that argument. Because even in the context of something which looks like a harder age rule, namely particular cell size, the Strasbourg court is saying, no, we don't do that. and we take account of the fact that these sorts of bodies perform very different functions, the court will, as it puts it in the final sentence or the last two lines on the on page 1884 in 113, they'll remain attentive to the standards developed by the CPT in that case in relation to cell size, but it forms its own view. And how does it do that? It does it by taking into account all the relevant circumstances before deciding whether Article 3 has been breached. So we do respectfully submit that those paragraphs are very, very important in describing the Strasbourg approach to the materials. And that explains why the judgments are structured as they are. I mean, sometimes you'll get a massive international material with the court, as it were, seeing if there is a flavour, a trend, a strong trend, a value, a hard-edged, something that looks more like a hard-edged approach or principle. How great is the degree of consensus? It all goes into the melting pot in the early parts of the judgment. And then when they come to the analysis, this is a description in action in relation to the CPT of what they do. And Lord Stevens, yeah.
Yes, thank you very much indeed, Sir James. Doesn't the court then go on at paragraph 120 to, in effect, adopt a strong presumption? Rather than adopting wholesale the CPT approach, they have a strong presumption instead.
My Lord, they can do, and they do. I'm going to come to strong presumption as a separate topic in due course. They can do in certain circumstances, and they can do in relation to certain things, but they are still applying this approach in 111 to 113 in principle to those international materials, even though they reflect, or could be thought to reflect, both a Council of Europe thing and a consensus thing, with the CPT going off and doing its report.
Is there any case that you can think of where, I agree with you, the sections of the European Court's judgments, they put in large chunks of international documents, and but can you refer to a case where they have specifically declined, positively declined to follow them, and so that, I mean, this is one case where they have gone for a halfway house, but have they positively declined ever to follow a consensus formed in the Council of Europe?
Well, my Lord, I think the answer to that is, I can't think of a case in which they say we simply don't agree. That's the value.
Yeah.
Again, being a tactful international body, their declining to follow tends to be indicated by absence. So there are plenty of cases in which they cite lots of international materials, and then when they get to the analytical part of the judgment, they simply don't refer to them, or they don't place reliance upon them, or they say in terms we agree with them or consistently with. So there are the range of approaches that you see.
I don't have the details to hand, Sir James, but Lord Lloyd-Jones will be as familiar with this as I am. But it occurs to me that there have been cases to do with UN General Assembly resolutions where the court has adopted an independent approach. Thinking in the context of detention of suspected insurgents in Afghanistan and Iraq.
The Sardar Mohammed type case.
Yes, that sort of case, and Hassan and so forth. You know, it's all frankly a dim memory at the moment. But my recollection is that the court wasn't prepared to follow the letter of the UN resolutions. It's certainly true of the ECJ, but I think it's in relation to sanctions cases. But I think there's also Strasbourg case law, which has distanced itself from the UN. I could be wrong.
No, I think you're right on recollection, because I think I did some of those cases before you, but the position there was slightly different, wasn't it? Because there was reliance, or purported reliance, upon the terms of a UNSCR as providing specific and identified grounds on which detention, in the context of Hassan, on which detention would be lawful.
Yeah.
And Strasbourg then grappled over a number of cases with whether or not that was directly coincident with Article 5 or it wasn't, ending up with their implication into Article 5 of a whole new ground on which you could be.
Oh, well, that's right. Yes.
Yeah, so it was a slightly different thing to the thing I think that Lord Stevens was asking about, which we could point to any case where they say, well, there's a common value or an international instrument or recommendation or something, and they've actually said, well, we just think that's not a good idea. I can't think of an example of that kind. But you have the full range. I suspect that the best way of describing it is you have the full range of reliance, if you will. No one's disputing that their judgments are redolent with references to all of these sorts of materials, but what actually happens when push comes to shove in the analysis is rather different. Sometimes bits of it are left on the shelf, sometimes bits of it are agreed with as conforming to the view they would otherwise have come to, and sometimes they are simply left out. My lord, yes, sorry.
The only example that I can immediately come to mind is called partnership, where certainly they were influenced by among and
sorry, you're a bit breaking up.
In the field of civil partnership, there was a case against Italy where they most certainly were influenced, from recollection, by what the consensus was, and in order to come to the conclusion that Italian law should make available civil partnership.
My lord, certainly. I mean, those are the sort of positive obligation examples that I had in mind. You don't have to go as far afield as Italy to find that principle in action. There were lots of cases involving the United Kingdom with the development of the various rights that should be accorded to those of homosexual orientation, and then of transsexuals, and all the rest of it. You get a whole raft of those, and influencing those cases is indeed a developing consensus amongst Council of Europe countries, and one sees it in all of those cases. So certainly there are examples of them relying upon a developing consensus in that particular context. But that is a particular context where they're deciding whether or not, as a matter of positive obligation, the contracting states need to alter their laws so as to accord rights which now reflect the development of moral values amongst Council of Europe states, which is perhaps a rather different context of deciding there's now built into a well-developed body of case law saying, look at all the facts, a hard-edged rule leading to per se violations if only you tick 2 or 3 boxes, which is what this appeal is about. So those were the points of principle on the soft and harder-edged international legal materials. Can I come more directly to the things that are actually being relied upon here? And so far as they are concerned, that's the UNCRC, Article 37, and the other materials relied on in the application. As I say, what we're looking for is to see whether there is in any of those materials something which would support the existence of the harder edge rule for which, or the hard edge rule for which my learned friend contends. The first point we make in relation to that is that Article 37 of the UNCRC, we respectfully submit, adds nothing to Article 3 of the ECHR in terms of its interpretation, and both the High Court and the Court of Appeal were right so to hold. See Court of Appeal judgment 73 to 75 in particular. Article 37 itself is obviously not part of domestic law, so it comes with all the health warnings that I indicated earlier. And we submit it's not really of any significance as an interpretive aid. It says nothing whatever about solitary confinement or segregation of children. its provisions are materially identical to Article 3 in any event, at least in relation to Article 37A, which is plainly the analogue to Article 3 because it's in virtually identical language. And we have some principal difficulty in seeing how you can rely on materially identical wording in another convention for the purpose of interpreting the same wording in a different convention. There's no need to rely on anything in Article 37A, for example. I'll come to 37C in due course. There's no need to rely upon anything to avoid international legal inconsistency or to achieve a harmonious interpretation. What my learned friend is in truth seeking to do is to drag across the entirety of Article 37 in all its parts, in effect as adjuncts to or detailed development of Article 3 of the ECHR, and that isn't a process of interpretation at all, it's a process of substitution, in effect. But there are particular reasons for caution in considering the attempt to introduce 37C and a fortiori the commentary on it by the non-binding committee, so that that in effect is directly translated into Article 3. The structures of those provisions are distinct as between the ECHR and Article 37 of the UNCRC. And that is because the ECHR splits out matters that affect the dignity of an individual, which is the stuff of 37C, as between Article 3 ECHR and Article 8 ECHR. And the divide it draws in that context is essentially and fundamentally based on seriousness. And in practice, in the Article 3 case law, dignity is invariably linked to physical punishment / assault. The equivalent of Article 3 ECHR is in truth Article 37A, and one sees it from the language. And the closer analogue to 37C is Article 8. And of course, Article 37 doesn't grapple with that distinction, just lumps them all into Article 37 and moves on. But it's critical for present purposes that the ECHR does draw that distinction in relation to the subject matter of 37C. The key issue here is whether the sorts of things that are covered by 37C can be taken as applicable, directly applicable in effect, to Article 3 ECHR in circumstances in which 37C of the UNCRC does not confront the sorts of things that might affect that distinction. Dignity that sounds in Article 8 as compared to dignity that meets the much higher threshold of sounding in Article 3. And there is no support, still less clear support, that even if there was a breach of 37C of the UNCRC, which is very far from clear, that would equate to a breach of Article 3 there. So what my learned friend Mr. Squires seeks to do in his submissions is to bridge that gap by references to human dignity in the Article 3 ECHR case law. But it is absolutely critical to understand and to recognise that those references in the Article 3 ECHR case law sit alongside and as part of the well-established general principles that are always set out in that little section of the judgments headed general principles, the well-established mantra, if you will, emphasising that the core feature of Article 3 is that you need a minimum and high level of severity before you enter Article 3 territory. It is not in principle anything which affects the dignity of a human being that is a breach of Article 3. Only particular types of treatment that affect the dignity cross that threshold. The rest may be relevant to Article 8, that doesn't concern. What are they? What are the things that affect the dignity that bring you within Article 3? Well, in principle, the answer to that is that you apply the general principles developed under Article 3. You look at all the circumstances and you see whether the thing that affects the dignity does so to such a degree as to cross the minimum and high level of severity required by Article 3 as a threshold. And in the case law, under Article 3, those have all involved physical restraint or physical punishment. So we submit that there is no translation from 37C into Article 3 ECHR of the kind for which my learned friend contends. And we then submit that nothing in the periodic reports or the general comment 10 or 24 can improve the position for all of those reasons, but also for the reasons of principle I gave earlier, which is that that committee, not merely commenting on a different treaty, and indeed an article which it might be thought is not the true analogue to Article 3, because that's 37A, for the reasons I've just developed, but that doesn't even give binding interpretations even of that convention, i.e. the UNCRC. That's no part of its functions. So Lord Wilson, we respectfully submit, was right, and Lord Bingham was right in Jones about those matters. In any event, we submit that you would need to consider carefully the content of any such report or other material relied upon. And all the various conclusions and caveats drawn by the Court of Appeal, where we respectfully submit properly, fairly and well made in relation to these soft international materials. That doesn't mean that they didn't take them into account. It doesn't mean that they ascribed no weight to them, but it does mean that they properly considered the content of those reports and what they were actually doing as part of assessing what weight, and we respectfully submit slight is about the right way of describing it in the totality, should be accorded to those in trying to make the judgment as to whether or not there is indeed in Article 3 of the ECHR the sort of hard-edged rule for which Mr. Squires contended. So in relation to those caveats in the Court of Appeal's judgment, if a provision of international law elsewhere or a softer piece of international law like a report is to be relied on as an aid to interpretation, it's got to be reflective of a clear, common, current position or rule we submit. Not just a recommendation as to future action, not about something different, solitary confinement as a punishment, rather than by way of protection of the individual, and supportive, ultimately and fundamentally, of a general hard-edged rule, not simply a view on individual cases. And those caveats are important in our context, not least because even something as basic as the term solitary confinement, on which my learned friend's hard-edged rule is fundamentally premised, itself needs careful consideration. We saw from the Strasbourg case law very, very clearly from the paragraphs around the 130 mark in Ramirez-Sanchez that even the degree of confinement is treated by the Strasbourg court and analysed by the Strasbourg court as a relative concept. I think it uses that relative isolation, then proceeds to analyse what degree. It doesn't have a kind of trip switch analysis. It doesn't say, well, once you've been in the cell for this length of time, you hit a certain point and then the rule becomes a hard-edged one. Indeed, that is the antithesis of the ECHR analysis. I'll come back to it, but I think at least one of the bodies, I think it's the UN rapporteur on torture, has himself acknowledged that even solitary confinement is a concept which has no uniform definition. It can mean different things in different contexts. Sometimes it refers simply to a number of hours in a cell. Sometimes it refers to something different. And if you're looking for the trip switch to the hard edge rule, even on Mr. Squire's analysis, you've got to introduce relative things like with minimal social contact. Well, that, as the Court of Appeal pointed out, immediately begs the question, well, what does that involve? And it immediately asks a relative question. So we respectfully submit that those caveats by the Court of Appeal were correctly made. I'm not going to go through all of them. We respectfully support the Court of Appeal's judgment in relation to all of the caveats that they drew. Just to pick up 3 or 4 particular types of soft law that were referred to and have been referred to. A general comment number 10 of the committee points in relation to that are perhaps, first of all, I'm not going to repeat all the points I've already made, but just on the content of it. On its face, the passage that is relied on by AB relates only to a, quote, disciplinary measure. And the Court of Appeal were right to reach that conclusion in paragraph 77 of their judgment on this comment. It exemplifies, it might be thought, why a bright line is not appropriate. On its face, it's looking at the dignity of the juvenile and the fundamental objectives of institutional care. And of course, in our case, those concerns were absolutely at the heart of the reason why AB was segregated. He was segregated for his own protection. So far as GC 24 is concerned, 2 points in relation to that. First of all, it wasn't in place at the relevant time, so can't bear on AB's case, even if materially different. And secondly, and I'm not going to repeat the points given the time, but there is considerable caution needed, we submit, as to precisely what is properly to be derived from GC 24. See the points made, I don't repeat them, in our case on that document at paragraph 69. So far as the CPT is concerned, clearly CPT reports have been relied upon in the past, and their views have been taken into account by Strasbourg. And I took you to what I respectfully submit is the correct approach in principle, and the correct notes of caveating that one can see from the correct approach in principle before simply saying, well, there it is. They've said that in another context, they regard that as being inhuman and degrading treatment, ergo it must be here. Those notes of caution sounded in paragraphs 111 to 113 of Merzic. But we also respectfully submit that the Court of Appeal was very alive to the potential significance, at least, of this document, because they subjected it to fairly close critical analysis. They did so at paragraphs 98 to 100 in their judgment. And again, we respectfully submit that they made no error in their approach to this document in those paragraphs. but that they considered it with particular care is clear from the passages that they cited, the bits that they emphasised, and the conclusions that they drew. And my short submission is that that passage in their judgment on this particular report, which is of obvious interest for the reasons that you were discussing yesterday, were correctly and fairly made. And in particular, there is nothing in here that could lead to or support the proposition that there is a hard-edged rule within Article 3 of the kind for which my learned friend contends.
That strikes me as perhaps the important point. I mean, there are one might be critical of the Court of Appeal and the judge below for approaching the international material on the basis that that if, for example, it was a recommendation, then little weight should be attached to it. But if one is examining Mr. Squires' proposition, that's a rather different issue.
It is. It is. But then the note of caution went beyond that, because I know if I divined it correctly, my lord was struck, or some of my lords were struck by the thought, well, if they concluded that in relation to, is it Cookham or Crookham Wood, if they concluded that there, why isn't it similar here? But even in relation to that, there is a note of caution which is fairly made. It's quite difficult to disentangle precisely what combination of factors it was that led to that finding. And of course, even if that was a finding of the committee on that, we saw from Merzic that the court looks at all the circumstances of the particular case before it. And here you'd be dealing with a case which exhibited all the features I outlined at the beginning, including particularly the fact that this segregation was for this individual prisoner's own benefit. And there were lots of safeguards that were introduced and all the rest of it. I'll come back to the fact at the end, but those are important caveats and fairly made. So that's what we say about the CPT report. The recommendations, which we've both been examining overnight, and I think there are two that were of relevance that Mr. Squires has identified. The first one was the one I think referred to in Buyid, which was the 2008-11 recommendation, and the second of them, which Mr. Squires found overnight, requires a little caution because it's called Recommendation CM Rec 2006-2, but one may need to be a little careful with that date for reasons that I'll come to. But those are the two recommendations that you're dealing with, and of course they contain a vast array of rules or purported rules or recommendations. So I think the 2008 one has 140 paragraphs, 142 paragraphs, some of which are divided into a succession of sub-paragraphs. And no one, I think, could possibly suggest or would be suggesting that those represent hard-edged rules in their totality that were simply to be transferred over and treated as rules. And indeed, that wouldn't be a fair reflection of what this Committee of Ministers function and recommendation function is doing. Indeed, it might be thought that if that was the way the courts were going to treat them, no state party would ever sit on that committee, because whatever they chose to agree to for the purpose of developing or pushing or examining would then be held against them as a hard-edged rule, which would lead to a succession of violations. So one needs a little realism and caution. We make 5 points in relation to those recommendations. The first is that they are another example of soft, and all the points that I've made in relation to soft law apply equally to them. Secondly, they are very clearly recommendations only, see, I know you were sent them all in PDF, but see the very face of each of the recommendations. They both refer to the terms of Article 15b of the Statute of the Council of Europe. And that says in terms, just to quote it to you, I don't think it's in the bundle, you probably don't need it, you probably know it. In appropriate cases, the conclusions of the committee may take the form of recommendations to the governments of members, and the committee may request the governments of members to inform it of the action taken by them with regard to such recommendations. So again, very much prospective, recommending that governments prospectively take these things into account and develop towards this place. So these are aspirational in nature, and that indeed positively supports and enhances the nature of the function that they're performing for the very reason I've just given. If whatever they sign up to is going to be treated as a hard age rule, no one would ever sit on. That they are non-binding recommendations has been recognised repeatedly in the courts. And I gave, after a little prompting, apologies we didn't give it to you earlier, the paragraph numbers in the cases we sent you this morning. It was only the two paragraphs in question, paragraph 33 of the KB decision, which really says little more, in fairness, than I had just said, and then is evident from the face of the page 1 of each of these recommendations, but is of interest because it's considering the very recommendation in question, which was 2008, the 2008 recommendation, 5th of November 2008, so of interest for that reason. And the second one was principally relevant to tease Mr. Squires, because it was he indeed making the helpful and thoroughly appropriate submission that you see recorded in paragraph 7 of that judgment. I say no more about it than that.
Can I just check? Do you mean paragraph 7?
Oh, have I got the wrong paragraph?
I think you may have.
I've simply got the quote from it in my speaking note, but can someone find me the correct paragraph before I tease Mr. Squires correctly? We'll ping it on an email and I'll give you the correct paragraph number, because it'd be a shame to miss it. The third point. The fourth point is that the European Court has also regarded these sorts of things as non-binding. And one sees that particularly from paragraph 53 of the Bouillard decision. And it's to be noted that in the court's judgment, that there isn't any specific analysis or reliance upon the specific recommendations, even though there was a particular rule there, rule 90.1, which related to the use of physical force. And that perhaps gives rise to a key point which needs to be borne in mind, which is that even if all of these can be regarded as rules of some description, conforming to the sorts of things that I was referring to when dealing with the points of principle about soft international law, there is nothing whatever in the case law to suggest that they are being treated as creating the sort of hard edge rules or approaches for which my learned friend contends. So even if you breach them, let's make that point stark, even if you were to be found in breach of them, it doesn't follow that ipso facto there's a breach of Article 3.
If I can interrupt, I think it may have been paragraph 48 of Steinfeld that you had in mind.
Is it 48? I'm sorry, I'm grateful, my lord, of it.
That's where Mr. Squires points out that it's simply a recommendation.
That's exactly it. I'm sorry, my note is well, it's a great shame that was the first typo we've come across. The joke is never quite as good when made twice. Anyway, 48 it is, thank you. The fifth point is that the content of the recommendations doesn't take matters any further anyway, we respectfully submit. So just to flick through, if you have those if you have the 2008 one to hand. Or to screen. Rule 19 is simply, we submit, stating the self-evident proposition, I'll come back to it when I deal with resources later, that resources can't be used as a justification where there's been a breach of human rights, and we entirely accept that. Article 3 is absolute in that sense. It can't be justified. But that doesn't mean that resources are irrelevant when you're considering the various factors and the explanation for particular parts of the treatment. I'll come back to that point, but that's all that Rule 19 is saying. Rule 95.3 on solitary confinement the core point to bear in mind in relation to that is that it sits, as you will see from the italicized title, about 7 or 8 paragraphs up, E.13.5, italicized title, Discipline and Punishment. And that's why no doubt 95.3 is in the form it is. Solitary confinement in a punishment cell shall not be imposed on juveniles. And that is to be contrasted under the previous heading and the paragraphs marked 93.1 and 93.2, separation for security and safety reasons. So not punishment, but protective, where the thing is cast in very different and looser terms. But there is nothing in any of this which suggests in any event, even if you were to take discipline and punishment as applying to a situation where the segregation is protective, there's nothing in any of this that suggests that you immediately go or move, as it were, to a hard age position under Article 3, or the court would go anywhere near that. They would simply take these values, if you will, into account and come to their own view on all the facts. Recommendation 2006, revision 2. I think the critical point to bear in mind in relation to...
So James, before moving on from 95.3 and 95, I was just wondering why the qualification that the regime in 95.4 shall provide, during such segregation, shall provide human contact, appropriate human contact. And so if you change the purpose to protecting the individual, AB, why shouldn't that qualification also apply there?
Well, it doesn't. You don't see anything like that reflected in 93, which is the bespoke set of paragraphs dealing with separation for security and safety reasons.
I appreciate that.
But precisely,
yeah, sorry, I do apologize.
It's unclear precisely how they all hang together, but you don't see anything equivalent there.
Can you see any justification for when you punish somebody, making sure that they have appropriate human contact, but when you're protecting them, they don't?
Well, my lord, you may be right. It may be implicit in 93.1 and 93.2 that they need appropriate human contact and so on. That's why I said, even if you assume that you can in some way transpose this into separation for security and safety reasons, and the boundary, as I fully accept, is, as a matter of interpretation of this document internally, uncertain and a bit poorer, potentially, for the reasons inter alia that you've given. There's still nothing to suggest that you've got a kind of hard age rule. You've still got relative concepts about the degree of human contact. So that feeds directly into the Ramirez-Sanchez approach in relation to adults, say, where they look at solitary confinement as a relative concept, see how much isolation there is, what's appropriate human contact. What about granting access to reading material? Is that to be treated as absolute? 1 hour of outdoor exercise every day, supposing that on a particular day you only have half an hour. Does that automatically lead to a breach of Article 3? Answer, of course not, we respectfully submit. So even if you take, and I see the force of what my lord has put to me, even if you take those sorts of things as being implicit in the protective context, they still don't lead to anything other than exactly the approach to which the Strasbourg case law indicates anyway, which is an analysis of a whole series of relative factors. That's, I think, the way I'd answer that question for my lord.
Okay.
Well, I was going to the other recommendation, unless there was anything further on that. And the key point to bear in mind in relation to this document is that although it is called 2006 Rev 2 and had a previous version, it was amended from the previous version, as you see in the preamble. And you see the date on the top right-hand corner of the first page of it, of July 2020. That was in effect when the amendments came in. And you have the previous document, which is entitled the European Prison Rules, in the bundle, which you can see from the top of the document. I'm going to give you the reference to in 1 second, that it's the same thing. It's the 2006-1 version, if you will. But if you go to EF 1009, you'll find the European Prison Rules. If you go to 1010, in other words, 2010, and just look at the title on that page, you'll see, I think that this is the same document, as it were, but before the amendments that were made in 2020. And the significance of that, at least potentially, is to see that the provisions dealing with detained children were those set out in paragraph 35 on page 1011. And in relation to solitary confinement, if you look at page 1012, note paragraph 60.5, solitary confinement as a punishment, that's all it said. So when you get to the, Muller, I'm sorry, yes, Mr. Lord Sales.
Sorry, it's a small point. I don't think in the bundle we've got the full text of these prison rules. It was just a request, but ask whether they could be supplied, please.
My Lord, of course. But I think I'm right in saying that this is the same document prior to the amendments and revisions, and that those amendments and revisions occurred in 2020, so a very long time after the events with which we are concerned. And that is significant if my learned friend is seeking to rely on the later 2020 version and the various developments that occur and the more absolute looking rules that appear now to be set out in, for example, para 60.6a of the July 2020 document. And I would say, even in relation to that rule, it's still a non-binding rule, and it still doesn't follow that even if it's breached, you've got that hard-edged rule that leads automatically to a breach of Article 3 if it's not conformed to. But the core point for present purposes is that you're not dealing with that document at all, because those changes only came in 2020. I wanted to give you one reference, moving from the recommendations to the reliance on, not so much orally, but in the written case, on the medical penological expert reports, in inverted commas. I think in the written case, at least, my learned friend is seeking to present those as presenting a unanimous picture, but we respectfully submit that there is no such unanimity. And the reference which I was struggling for earlier on to the UN Special Rapporteur's report is the reference to his report at paragraphs 25 to 27, electronic 2181 to 2, making the point that there's no unanimity even on something as basic as what amounts to solitary confinement. And the short point in relation to the attempt to rely upon medical evidence is the factual one, which is that there is no suggestion that there was any deterioration in this individual's mental health as a result of the treatment. So the overarching point, before turning to strict necessity, the overarching point is that the Court of Appeal recently considered with care all of the hard and soft international law. They were very well alive to the need for caution in relation to those, for all of the correct reasons of principle that I've respectfully submitted to you this morning. They didn't reject consideration of any of those in principle. They took them all into account. And there's no suggestion that they didn't. That is why my learned friend has to put it higher than that. And he has to invite you to say that the conclusion they should have drawn from those is not merely that they were relevant to the consideration with those appropriate notes of caution, but that they formed the basis, inevitably, for the hard-edged rule for which he contends. So turning then, if I may, to strict necessity or exceptionality.
I wonder, Sir James, if you're
that might be a convenient
turning
moment.
to the second ground of appeal, effectively,
Yeah,
this might be an appropriate moment for us to have a 5-minute break.
my lord, it might.
Yeah.
To
In
be
that case,
dash when it comes back, but it might.
in that case, we'll adjourn just now for 5 minutes.
Grateful.
I think we're ready to resume, Sir James.
I was going to move to strict necessity as the test, or the suggested test by Mr. Squires, where there is, as he puts it, prolonged solitary confinement, whatever those concepts relatively may mean. And the first point we make in relation to the suggestion that that is the correct approach under the European Convention on Human Rights is that there is no such test and no suggestion of it at all in the European Court's case law. On the contrary, the approach that they have consistently and repeatedly described ascribes relative weight to all of the circumstances in the analysis. The purpose or the reason for the removal from association and the intention of the state in that respect is already acknowledged as a factor of importance, but it's no part or constituent element of Article 3 analysis to show that the treatment was strictly necessary. For reasons you'll understand, I submit it was anyway, but I'll come back to that. That's the first point. The second point is that the case law relied upon in support of the proposition for which he contends is all about physical force being used against the detainee. And it is entirely unsurprising that that is so, and indeed that that sort of measure involving physical force does need to be strictly justified. So in Bouillon in Belgium, the applicants had been slapped in the face by the police. In AP in Slovakia, there was a minor who'd been slapped in the face in the course of an arrest. In C, in the Court of Appeal, Lord Justice Buxton, making Natalie Leven, as she then was, his life very difficult, I suspect, for a day or two. That involved the restraint of children in detention for the purposes of good order and discipline, GOAD, as it was called. Agger Home in Denmark, on which my learned friend majored, 1527 in the authorities, physical restraint for almost 23 hours of a mentally ill patient detained in a psychiatric hospital. And there, the clearest expression of the principle is at paragraph 82, page 1555, where the court said, in respect of persons deprived of their liberty, recourse to physical force, which has not been made strictly necessary by their own conduct, diminishes human dignity and is an infringement of the right set forth in Article 3. And the Matthews case, to which Lord Reid referred yesterday, and which we sent you as the third of the authorities overnight or this morning, draws the point out clearly. And as Lord Reid, that is, pointed out yesterday, there is a pretty interesting contrast between the use of force paragraphs and analysis, which uses the language of strict necessity, 176 to 179, and solitary confinement, which does not, 197 to 205. The appellant then seeks to rely on Ahmed and the UK, 212, to say that's at pages 1626 and 1627, to say that there's an exceptionality test in relation to solitary confinement, which is to all intents and purposes the same thing as strict necessity. Well, the first answer to that is it isn't, particularly in the way my learned friend sought to define strict necessity. And the second thing to say about it is that, in truth, when one analyses the way in which the court approached the issues, both in Ahmed and when using substantially the same language in Ramirez Sanchez, what you in fact see is that they go through all of the circumstances and they treat them all as being relative, and then they weigh it up. True it is that they ascribe more importance to some than to others, but that's simply part of their overall approach. As they put it in Ahmed at paragraph 178, page 1619, all of these elements, said the European Court, depend closely upon the facts of the case. So the appellant has pointed to no case in which Strasbourg has applied the strictly necessary test to solitary confinement or segregation. And the two cases which he does cite do not apply that test or even support that proposition. So what my learned friend then sought to do, perhaps recognising those difficulties, was to elide or seek to elide through various passages, I think it was in Agahome, to seek to elide physical force with seclusion. My respectful submission in relation to that attempt is that they are plainly distinct as concepts and relevantly distinct for present purposes, and there's nothing in the case law to suggest that you would get a strict necessity approach as long only as you can bring yourself within the concept of seclusion, again, whatever that concept may mean. In a similar vein, my learned friend Miss Gallagher then sought to suggest that there should be a presumption of breach, triggered, I suspect, by the same sort of ideas, relative though they may be, of prolonged solitary confinement. As she correctly noted, that is not a line of argument that is being advanced by the appellant. But three short points to address it head on. Firstly, there is nothing in the European case law to support that either. I should make clear that no one disputes that sometimes Strasbourg has used the idea of a presumption or a certain facts triggering a presumption of breach as an analytical tool. That's entirely uncontroversial. But in the context of Article 3, their approach is well established. It involves looking at all of the facts and circumstances, no doubt on particular facts, ascribing more or less weight to particular individual factors. But it does not involve the application of presumptions, and certainly not the application of presumptions in relation to or triggered by solitary confinement for a prolonged period. Indeed, those examples of cases where the presumptive language has been used have been either the fraught issue about the fraught quantitative issue, it might be thought, quantitative issue of cell size in Mersage, but more often in relation to presumptions that flow from a person being injured in detention, where it's perhaps entirely evident or clear why the presumption is introduced in principle. Secondly, there is no need or warrant in principle to depart from the Strasbourg case law in the way that is suggested, precisely because that jurisprudence allows for all of the features of detention, including relative isolation and duration of segregation, to be taken into account and ascribed their own weight. But it does so critically alongside other matters that bear on whether or not the minimum threshold of severity has been breached or reached. Conditions of detention, medical health, the intention of the authorities and all of that. And indeed age itself. But that is also a relative thing, to be seen alongside, no doubt, maturity, vulnerabilities, including mental health issues or not, all feeds in to this overall approach. And thirdly, the design of any presumptive principle, it might be thought, illustrates the difficulty with its existence, and indeed with the lack of necessity for that approach. That, I think, is the point that the Court of Appeal were making at paragraph 68 of their judgment. The moment you introduce evaluative or relative elements into the trigger, it ceases to be a principle or a hard-edged thing. Meaningful contact, duration, how long out of cell, what activities, all feeding in to the approach which we've indicated. I wanted to say something very briefly about procedural matters and processes for reviewing detention and so on, and then something about resources before very briefly dealing with the facts at the end. But so far as the procedural matters are concerned, again, we acknowledge that the procedural safeguards that exist under domestic law for the review of detention and necessity and so on are regarded as relevant and important by the Strasbourg Court. But the position is plainly that the mere fact that you have not complied with what your domestic law said you should do in terms of frequency of review may be dispositive in terms of a breach of Article 8 with its requirement that any interference be in accordance with law. So if you breach your own domestic law, it's not in accordance with law, and that was the finding of the courts below. But it is plainly not dispositive what would happen if you missed one or you were a day late. It is plainly not dispositive, although relevant, in relation to an Article 3 breach. And that it is not dispositive is evident from the Shahid case, the Supreme Court Scottish case to which reference has already been made. See for that purpose paragraphs 28 and 37 at bundle 1376 and 1378, which indicate that there was a failure in procedural respects in that case, but there was nevertheless no breach of Article 3. And exactly the same position inured in the Dennehy case, Mr. Justice Singh, paras 72 and 129 at pages 2309 and 2319. So we respectfully submit that the Court of Appeal were right at 148 in the conclusion that they drew about the failures that there had been in relation to process. And I leave on one side at least the question mark that has been raised in relation to this issue about failure to follow procedures and their relevance to substantive breach, raised in a very different context by Lord Justice Leggett in the Seed case, the other Seed case, not the Lord Justice Buxton one, paragraph 116, that was the two-child rule case, paragraph 116, page 1227, which is salutary, if only as a reminder of the continuing authority of misbehaving. In other words, you judge the substantive breach on the basis of the objective factors rather than by whether or not you follow the correct process. So that's what we say about processes. Resources, then, if I may. The Court of Appeal, I emphasise, did not find that resources justify a breach of Article 3, as the appellant appears to contend. But they did conclude that resources could be relevant in considering one of the circumstances that feeds into the overall treatment of an individual. And that is particularly so when, as they noted, positive obligations on the state to provide or not to provide certain things might be engaged and involved. Relevant for that purpose because it might provide an explanation or a reason for the difficulties of providing a particular benefit or a particular enrichment of the environment in which the prisoner is sitting. In other words, or for example, access to teaching. That's the approach the Court of Appeal took, see paragraph 144 of their judgment. And there is an important point of principle here, it might be thought, about the intersection between Article 3 and Article 8 for this purpose. The point is framed by the fact that Mr. Squires now accepts that segregation, separation from other inmates in its totality, was both justified and appropriate throughout the period that you are considering. And by that, I take him to accept that it was both necessary and strictly necessary for that purpose. So it is really now all about education and possibly a little bit more time out of cell that is said to lead to Article 3 violation. And on this point of principle, he also accepts that under Article 8, resources and the fact that there may be limitations on staff numbers, that resources are stretched, would be relevant and might well provide an explanation for / justification of the non-provision of what Lord Sales described as the richer environment. But if that is so under Article 8, it is impossible, we respectfully submit, to see why, when considering that inability as an integral part of the treatment to which the individual is subjected, you couldn't in principle also take that reason into account when analysing Article 3. That is not the same thing as justifying a breach of Article 3 by reference to resources. It does involve, however, avoiding what would be a totally unprincipled dichotomy between Article 8 on the one hand and Article 3 on the other in relation to precisely the same sort of issue. Indeed, it might be thought to be a fortiori in relation to Article 3. Why is it that you can't, for the more serious article, explain why non-provision happened? And the cases that my learned friend relies upon in that respect are simply, we respectfully submit, not in point. There are either cases in which resources didn't arise at all, Merzic in Croatia, or there are cases where the court had already found a breach of Article 3, or Chowski in Poland and so on. So we respectfully submit that there is nothing to be derived from the Strasbourg case or indeed from the C case in our Court of Appeal that supports the idea that in terms of analysing Article 3, not in the context of a policy, but in the context of explaining why particular treatment happened to an individual, you couldn't take into account that as an explanation. So I come finally in the last 5 minutes, I return full circle, if I may, to the facts and the application of all of these principles to the facts. And we do invite the court to read. I've set up my stall right at the very outset of my submissions, and I know you have our basic position in relation to that, and I don't wish to go back to that. But there was some suggestion, I think, by Ms. Gallagher that Lord Reid reminded me of, that paragraph 54 of my learned friend's written case, that's Mr. Squires' written case, opened the door, as it were, to go beyond the points of principle on which he relies and to re-argue in some way the fact, or to say that everyone got it wrong in the courts below. But we respectfully submit that, properly and fairly read, paragraph 54 of that case, which is on electronic page 28, is simply summarising ground 2. My Lord, yes, Lord Sales. So you're on mute.
I think it's just to pick up, it's the notice of appeal rather than the written case, but you've given us the right page reference.
Yeah, notice of appeal, I'm sorry. But we respectfully submit it's summarising ground 2, which is about strict necessity. It's the point of principle. In any event, if you... yes.
But if you go to page 23 of the electronic bundle, the first ground of appeal is headed erroneous approach to international materials in determining whether there was a breach of Article 3.
Yeah.
They go on to define that as being the per se breach, but they do refer to all the principles. For instance, failing to treat the recommendations. So, so the point that was raised also has, as part of its reasoning, that there was an inappropriate reference to international materials. And so even if they don't succeed on a bright line argument, they may be able to establish on the basis of those grounds that there's been some other breach of some other incorrect approach by the Court of Appeal in the way that...
Well, they may. But ground one, particularity referred to at paragraph 42, which you were reading from, raises all the points and principles on which I've made submission. And the alternate case, which is ground two, says, well, if that's wrong, and you haven't got a per se rule, you've got something which says strict necessity.
Yeah, but
I'm perfectly happy to engage with those arguments, and I have done.
Yeah, but the I think it also brings in paragraph 152 of the judgment in Finucane, which Lord Hodge would be familiar with, and I think you also would be familiar with, where Lord Kerr postulated, what do you do in circumstances where the court discerns a breach of a convention right, but the parties haven't articulated it in exactly the way the court discerns it. And so he didn't finally decide that point because he thought it was implicit in the argument that had been raised that it was covered by the grounds of appeal. But I was just wondering why we are confined to exactly the way that the appellants have framed their case.
Well, I mean, my lord, I think the short answer to that is that this court is omnipotent, which is why I'm about to deal with the facts. You
Right.
pretty much do whatever you want when you come to the ultimate analysis, but traditionally, grounds of appeal are laid out. They set out the points you want to argue. Permission is granted or not on that basis. And the court is normally very wary about allowing a whole new raft of attack. For example, moving from a point of principle to the point of fact. But my lord, I don't want to spend too much time on this because I'm already about to run out of time. I wanted to make points on the facts, just in case you found a way around the argument that these were points of principle.
Well, I have taken over from Lord Kerr.
Well, I'm not allowed to say, I'm hoping not. My lord, coming to the facts, if I may, our short submission is that the lower courts considered the facts with conspicuous care, and there is no basis anyway, even if you get to this point, for concluding that they dealt with those facts in a way that was wrong, to use the appellate concept. And it's very, very important to take into account and to note that both the High Court and the Court of Appeal took heavily into account the fact that they were dealing with a vulnerable child. I mean, the paradigm paragraph, you can have a paragraph that is paradigm, is the Court of Appeal paragraph 110, where they make that point in terms, but it runs throughout the judgments. Paragraphs 110 to 111 in the Court of Appeal particularly, and 143 in the Court of Appeal. In the High Court, 70 to 83, Mr. Justice Ouseley, 86, 93 to 107, considering the international reports on children, 115, 116, all the way through, thoroughly alive to and took into account and considered the fact that this was a child. But there were strong features suggesting no breach of Article 3, which they correctly also analysed. The justification was self-protection, not punishment, certainly not humiliation. He couldn't mix with others for his own protection. And it's accepted, positively accepted, that that entire part of it, non-mixing with other inmates, was justified and necessary for his own protection. The mental health issues are relevant and were treated as such. They were fully alive to the fact that he had mental health issues. They no doubt contributed in part to the self-created threats that he created for himself, leading to the need to segregate. But there was no deficit in his psychiatric or social management care, social welfare checks were conducted, specialist psychiatric care was provided. There was no deficit here. There was nothing to indicate that he suffered any deterioration whatever in his mental health in this period. He wasn't in total isolation. His was a relative segregation for good reason from other detainees. So now, in truth, as I indicated earlier, Article 3 turns on the lack of education, which should, of course, have been provided earlier, and potentially a little bit more time out of cell. I don't diminish the seriousness of that, but it's clear that it was an error and or a lack of fuller resources. There were particular issues in his case with trying to get him into a place where he was in the mainstream where all of this would be provided, but those fell apart for reasons related to his own behaviour. There were particular issues in his case because half of the cohort, indeed many of the teachers in the prison, were female in the units, and he couldn't have them because he couldn't be left alone with those teachers. And in truth, the education that wasn't provided for a relatively short period of weeks. And when the mistake was highlighted, there was an appropriate and relatively swift reaction by the authorities. And if you wanted more references on education and the story in relation to education, the High Court perhaps, the High Court judgment, paragraph 26, paragraph 8, Court of Appeal, paragraph 124 and 125, and then 137 will give you at least a flavour of that. But it isn't, we respectfully submit, when it narrows down to that point, it isn't the stuff of Article 3. It could perhaps be the stuff of Article 8, but no part of the appeal relates to Article 8. He sought to introduce Article 8, sought to appeal in relation to that, and that was rejected at the permission stage. See pages 33 and 55 of the electronic bundle. So we respectfully submit that for all of those reasons, this is not a case in which, in principle, it would be appropriate to introduce the sort of hard-edged, even the alternative hard-edged rules for which he contends. There's no basis in the materials for that. And even if you conclude that the appropriate thing to do is to treat yourself as a court of perhaps troisième instance, we respectfully submit that on the facts, we're nowhere near the level of severity that would be required for an Article 3 violation to be found. Otherwise, those are my submissions, unless I can assist further.
Thank you very much, Sir James. We turn now to Mr. Squires for reply on behalf of the appellant.
I'm obliged, my lords. Starting with the materials we sent overnight and my learned friend's submissions on those. I won't take you through the notes that we sent. What you see from starting with the 2008 recommendations is, we submitted, and my lord put to me yesterday, that one shouldn't be looking at these various recommendation rules just for what they say about solitary confinement. One also needs to look as a whole what they say about how children should be treated in custody. And the 2008 recommendations, you'll see from our note, refer to regimes aimed at educational, personal, social development, vocational training, meaningful interventions. This is 3.4 of our note, quoting from the recommendations: meaningful activities, time outdoors, time out of cell. Also, measures taken against children to be strictly necessary. And all of that, we say, taken as a whole, goes to what it means to treat a child in detention with dignity. It does require at least some level of education, meaningful human intervention, physical exercise, fresh air, purposeful activities, and all of that's reflected in our own YOI rules, 3, 37, 38, 41, which you have at 965 to 968 of the... My lord, yes.
Sorry, on what you said I'm so sorry. It was just to pick up on what you said about these indicating what it means to treat a child with dignity. And it's really to repeat a question I asked you before. Dignity is a value which underlies the whole of the convention, so Article 8 as well as Article 3. It's not enough, your argument, is it, just to say that these give indications as to what it means to treat a child with dignity? Because you're having to try to push your dignity aspect of the case into Article 3, where there's another home for it under Article 8. I just wondered how you deal with that in relation to this general proposition that you're putting to us.
But look, we absolutely accept, and that was the point that I was coming on to, is what our submission is, if you remove all of that, and that's what essentially solitary confinement is. Solitary confinement is removing effectively the entirety of what we think of as required for children. In this case, that's 23 hours alone in a cell for weeks coming up to months, with no education, no physical activity, very little time outdoors, virtually no meaningful human interaction. So our submission is, when you have that complete, what solitary confinement is a complete removal of everything that we think of as key. So my Lord is exactly right. All of those, the gamut of things are all about dignity. When one is, what solitary confinement does, and it did in this case, is almost a removal of all of that notion of treating a child in a way that requires purposeful activity, interactions, education. And that's why we do say we get beyond Article 8 and we're into Article 3. That's my submission. We also will refer to the, as Sir James said, to the European prison rules, paragraphs 5 to 7 of our note. And Sir James noted that certainly some of the more recent updates was updated in 2020, which is correct. But what you'll also see, and we refer to this in the note, is that it was updated with particular reference to the CPT reports. And of course, one of those, and certainly the one that we know that deals with solitary confinement, is the one related to Cook and Wood, which related to events in 2016, which was the finding there of inhumanly degrading treatment, which I'll return to. And what we now see in the European prison rules is again the prohibition on solitary confinement of children. So it's yet another, and I'll come on to this. I mean, had this been the only document, one might say, well, look, it's only happened in 2020. But one, it relates to developments in CPT reporting, which we'll come back to. And two, of course, this is yet another in what seems to be almost everybody who's considered this issue reaches the same conclusion. Second point to highlight about these rules is a rule which we didn't, I apologize, refer to in the note, is Rule 53.2 of the prison rules. And this was in force, has been for some years. And the reason we know that is it's because it's referred specifically to in Ahmed and Ramirez Sanchez. This is where they get their exceptionality test from. And it was said by Sir James earlier, well, that's completely different to strict necessity. But if one looks at what's said in 53.2, it comes, certainly we say, perilously close to some sort of form of necessity. It's how we understand a proportionality approach in this context. It's only used in exceptional circumstances and only so long as security or safety cannot be maintained by less restrictive means. So it's from these rules that the court gets in Ramirez Sanchez and Ahmed the test that it does, and I'll come back to that. My Lords, going through the submissions to some extent in the order that Sir James dealt with. So yesterday he dealt with the question of the facts and challenges the facts, and he said we hadn't identified errors in factual findings, and he returned to that point this morning. And my Lord Reid put to Sir James that findings of a violation of a convention right is a special kind of fact, and Sir James accepted it was a mixed question of fact and law. And the Secretary of State is right that we're not challenging findings of fact in the narrow sense as to what exactly happened to AB, when it happened, indeed why it happened. Indeed, most of them haven't been disputed by either side. I will come on to some of the factual submissions that were made, but the primary facts, the conditions of detention up until the 2nd of February, the absence of any purposeful activities, all of that we get from the decisions below. And of course, and we also get why he was, from the decisions below, why AB was placed in, was certainly why he wasn't permitted to interact with other children, because he shouted threats out of his cell door. It is correct that we don't challenge those primary facts, but nor, of course, the Secretary of State challenge the primary facts about, this is Mr. Justice Ouseley, paragraph 133, routinely in his cell more than 23 hours a day, sometimes 23 and a half. He doesn't challenge the findings, and this was the quote I was trying to grasp for yesterday in response to a question from my Lord Sales from Mr. Justice Ouseley about education not being provided because not enough thought, effort and resource have been put into it, paragraph 31, page 238, nor Mr. Justice Ouseley's finding 125, that he should have had education earlier and would have got out of his cell more if he had done so. But as I say, it's accepted that ultimately whether treatment is degrading is a special sort of fact, a fact and degree question. And the issue for the court is if there's been identified errors of law in the courts below's analysis, how they approached the question that was before them, how they approached the degrading issue, if there were errors in relation to the international material, in relation to the Strasbourg material, then our respectful submission is that will make the special kind of fact conclusion on degrading treatment erroneous. And our submission is that it is open to this court to then reconsider it. We accept we have to identify an error of law in the approach, so in terms of the way we frame the appeal. But if we have, in terms of international material or otherwise, our respectful issue, and we will respectfully invite the court to consider with a correct legal approach, whatever the court concludes that is, whether the treatment here did cross the threshold to degrading treatment, and whether you've heard our submissions on what we say the consequences of the error are, or what the court should have done, whether that's per se, whether that's prima facie, but ultimately what we have to identify as an error in the court's approach, which then enables this court, if it agrees, and if it's minded to, certainly to reconsider the facts, and as I say, because the facts are not, the primary facts are not in dispute. And our respectful submission will be, I'll come on to the more detail of the errors of law, particularly when we look at the international material. But ultimately, the error is, in our submission, a failure to appreciate the significance of solitary confinement for children. And we get all of that from all of the body of international material. But the approach the court took, and the approach that Sir James urges upon you today, is essentially to treat being a child as another factor in relation to solitary confinement. But we say that isn't how the whole raft of international materials deal with it. They treat it as a difference in kind, not simply as a difference in degree. And part of that links to what I began with, what it means to treat a child with dignity, which is quite different to how we think of treating an adult. And insofar as the courts below didn't give that the correct weight from the international materials in particular, then that would reflect and infect the decision on degrading treatment. Turning to the factual matters that Sir James dealt with, firstly, the reasons for AB's treatment. Sir James was very careful when he went through the facts to refer to the justification for AB's segregation, namely to protect him from other detainees. At no stage did he rightly say there was any justification for placing AB in solitary confinement. Every one of the references he gave to the judgments below, and this is the same with the judgments below, at no stage did any of them make a finding that it was justified, necessary, required to place AB in conditions of solitary confinement. And the clearest indication you have that it was not necessary to keep AB in solitary confinement to protect him from other boys was that once the Howard League intervened, 19th of January, the YJB intervened, 20th of January, you have the meeting on the 24th of January, measures are put in place. He ceases to be held in solitary confinement. It's very limited, but he does get purposeful activities, he does get education, and no one suggested that his risk changed. No one suggested, or the risk to him changed. No one suggested he ceased shouting out of the door of his cell. It was a manifestation in large part of his mental health difficulties. And he still wasn't allowed to mix with other boys until early March. So the fact that it changed at that stage is about as clear an indication as you will get that it wasn't necessary. It happened because thought was not given to it. We'll come back to that in terms of procedural safeguards. Sir James also said reviews were conducted, but not with the frequency they should have been. And he referred to two paragraphs in the judgments, Judgment from the Court of Appeal 137 and High Court 127. But again, all of that refers to reviews carried out from the 24th of January. All of that are things that happened on that date or afterwards. And that's and this ties to the point Sir James dealt with right at the end about procedural safeguards. And perhaps I can deal with it now. The issue isn't if you have any breach of a domestic requirement of a kind in Shaheen, a sort of technical breach, therefore you breach Article 3. That's not the submission. The submission is that if you have no process at all, we don't even know who the decision maker here was, if indeed there was one, who said, I decided this child needs to be in solitary confinement. And that's the problem, and that's why you end up with a child left in these conditions. We say, and that's what the Agarhole case are getting at, why you need procedures to make sure that if you're doing something like this, on any analysis, we'll come back to the strict necessity test, exceptionality test, on any analysis, it is a severe measure. And unless someone actually directs their mind to it, you end up with it being imposed where it's quite clear here. As soon as anyone thinks about it, you realise this child obviously shouldn't be kept in these kind of conditions, and things change. So James referred to various interactions. Oh, apologies.
Yes, thank you. You said thought wasn't given to education, but I rather had the impression, both from the judgments and from the evidence, that efforts were made to integrate, and more than one, to integrate AB into other units. The hope being that he would then be part of a cohort that would proceed and have education in the usual way. But those efforts failed because of his behaviour. I just wonder whether it's actually correct to say that no thought was given to education generally, given that those efforts were made.
No, yes, perhaps that was, I'm sorry if the submission appeared unfair. No, I mean, efforts were made to integrate him. That's about ending the removal from association. What thought was not given to, it would appear, and that's certainly reflected in Mr. Justice Uzi's judgment, is if we can't, if we're not going to allow him to associate with other boys, how can we still provide him with education? Because that's the requirement. It's, as I say, separating from other boys is maybe lawful. It's certainly lawful under the YOI rules. Solitary confinement is not. And it's that one needs to give thought to. And as I say here, we know that 25% of the boys, or more than 25% of the boys at the time, were in the same position as AB. So what it suggests, and not receiving any education because they couldn't integrate. So that's what in part was being got at by not enough thought is given to it. But I accept, had he been able to integrate, had he been able to associate, the hope would have been that he would have been able to receive at least some education.
Yes, thank you.
Sir James then dealt with interaction with staff, and he mentioned, well, there was some interaction with staff during this first 55-day period. We deal with that in our printed case at paragraph 65. I think you can see from the records, there's about, I think, 10 or 11 occasions, we've referred, I think, to all of them in our printed case, where he has some sort of interaction, be it a welfare check from social services or something similar. We don't have any evidence of what they involve. They may literally have just been checks. And what we do know is at least some of them, and it may well be certainly, and it may well be more than some, it may have been all of them, were done through the hatch in the prison door. I say we know that for the chaplain. He records in 628 of the EF 628 on the prison records, I saw AB through his door on advice of staff. He said that he was okay. Well, if that was advice of staff to the chaplain, it may well have been the same to social workers. But in any event, we say none of that comes close on 10, 11 occasions in 55 days to meaningful human interaction that a child of that age needs. Finally, on the facts, so this was yesterday, Sir James referred to the medical reports of Doctors Hales and Adshead, and he referred to it again today. It says their statement, that their report of the 4th of April 2017, which you have at 884 of the electronic bundle, and he said they didn't find at that time an identified mental deterioration. And we accept that, but what they did say, and this is at paragraph 5.1, 5.2 of their report, 893 of the electronic bundle, is that placing children like AB in solitary confinement for prolonged periods of time creates a risk of long-term harm, which may not be detected at the time because of the uncertain effect on neural development. And they go on to explain that's why, or there is a strong professional consensus that solitary confinement is especially risky for adolescents. And so it's the potential to cause long-term harm that they identify, and that's relevant. We accept you couldn't detect any impact on him in 2017, but it's the potential for children, the potential, given that children are developing psychologically, socially, neurologically, to cause long-term harm that's led to, or one of the reasons that we see so many bodies saying, look, this may be acceptable for adults, but never for children. And it's referred to specifically in the BMA recommendation we saw and the NPM. So James took you yesterday to the various solitary confinement authorities, Ahmed, Ramirez Sanchez, and he notes in Ramirez Sanchez, there's reference to the stress on severe ill treatment for the purposes of Article 3. What Ramirez Sanchez says, and we see this throughout all of the, almost all of the detention cases, it's at 119 of Ramirez Sanchez. It is also reference to Article 3 requiring the state to ensure that prisoners are detained in conditions that are compatible with respect for their human dignity. And we see that, it's in Ahmed, and we see that line right across the board. And of course, in the Bouillard case and others, there's a particular recognition that when you're dealing with dignity of those in detention, and especially the vulnerable, the nature of the ill treatment, what gets you to the severity threshold, will be different from other cases, not necessarily a physical harm. What gets you there is the particular vulnerability of the individual, of an individual in detention. There's also in the authorities, and this is something that Sir James dealt with today, the repeated line about solitary confinement needing to be ordered only exceptionally and after every precaution has been taken. So that's Ahmed 212, Ramirez Sanchez 139. And we see that both of those refer to 53.2 of the European Prison Rules, which I mentioned, which is only for so long as security or safety cannot be maintained by a less restrictive regime. And what that's getting at, and indeed what the European Court is getting at in Ahmed and Ramirez Sanchez, is this sense that solitary confinement is, in fact, said expressly in Ahmed, one of the most serious measures which can be opposed within a prison system. So you do have to show, something exceptional, exceptional danger, don't do it any longer than is required for the security or safety of others, cannot be maintained by a less restrictive regime. And our submission is that is either a strict necessity test, or if it isn't, it's certainly a form of necessity test related specifically to solitary confinement, related specifically to Article 3. And in our respectful submission, it clearly hasn't been complied with here. And you saw our submission there at the end of our printed case on why both strict necessity and exceptionality tests aren't met. And perhaps the clearest indication of why exceptionality isn't met is the simple fact that at this time, I say more than 25% of the boys in Feltham were in solitary confinement. And it was the same, I think the year before it was 25%. And that simply isn't, it's nothing like the findings of exceptionality that are then made in cases like Dennehy, Shahid, Ramirez, Sanchez itself. That is not being used as an exceptional measure, last resort, etc. And one thing I should say, actually, in fairness to Feltham, I've been asked to say by my instructing solicitors, is if there are people listening from Feltham, that matters have improved very much in Feltham since these reports, since 2015, 2016, 2017, and now it appears that solitary confinement may well have been certainly massively reduced or almost eliminated at Feltham. So I should say that, in fairness to the YOI. In relation to the exceptionality requirement, it was treated by Sir James as being, well, just another factor that one considers, along with, I think he listed various points, sanitation, how often someone visited by doctors. But our respectful submission is that isn't conceptually how that should be understood, nor how it's treated by the cases. That is a distinct element. There's no sense in the cases they say, well, this really wasn't exception, it wasn't really required, solitary confinement, but the sanitation in the cell was fine, or but it only lasted for a few months, or whatever it is. Logically, it is a distinct test, and you see in the cases, in the authorities, that it is applied in that way. My other friend also dealt with the Matthews case, which we also looked at overnight, the Matthews and the Netherlands case. And of course, James is right, and as my Lord Reed noted, that the court applies a strict necessity test to physical restraint in that case, but didn't apply it expressly to solitary confinement. It did, however, find a breach of the solitary confinement requirement, paragraph 217, because the solitary confinement was for an excessive and unnecessarily protracted period. Now, of course, this case is in 2005, so it's before the European Prison Rules 2006, which are then referred to in Ramirez, Sanchez and Ahmad. So when they developed the exceptionality test, but certainly even in this case, the concern is excessive, unnecessary, protracted period is what leads to a breach of Article 3. And we come back to our submission that in this case, as far as solitary confinement is concerned, that is something was plainly excessive and wasn't necessary, and there's no evidence that it was something that was required, certainly by his behaviour, to protect him or to protect others. We're turning to the international material and the submissions made by Sir James today. He dealt with the international materials on the basis that all of them, or our reliance upon them, was all concerned with what he said was importing a hard-edged rule. Our submission is that the errors which we say were made by the courts below in relation to international material do not only go to our ground one argument, the per se argument, they also go to how we understand degrading treatment across the board, and particularly how it ties into an analysis of dignity in this context. So we do say, and that's why I took you I only dealt with relatively briefly the per se argument at the end, but all of the arguments about the international material, they're all relevant. If there are errors made in relation to that, they're relevant to they are relevant to the question the court is ultimately deciding, or the court should have decided, which is the degrading treatment issue, whether one says, well, per se degrading, whether one says degrading on the facts of this particular case, whether one says strict necessity test. The international materials all go to how the court should approach the question of degrading treatment in this context. So James said, well, one cannot treat unincorporated treaties as incorporated. We agree. What we're inviting the court to do, as far as the international treaties are concerned, is to ascertain what the international treaties require, and then, and it's in the word of Lord Justice Leggett in the C case, which the Secretary of State relies upon, it's paragraph 99.1221, is to interpret the convention in a manner that is consistent with other international instruments in order to avoid, as far as possible, conflict between different treaties. That's the analysis. The question is in interpreting Article 3 in this particular context, what does one do with both what we say the hard international law position, as understood by the various committees, which I'll come on to in a moment, and the whole array of soft international instruments, comments of different bodies. So James said, well, the international treaty provisions have to be relevant. And again, we agree. But we said it's plainly relevant in this context that at least the authoritative view of the bodies charged both with interpreting the UNCRC, but also importantly UNCAT. And UNCAT is concerned only with cruel, inhuman and degrading treatment. Both of those bodies have repeatedly said the solitary confinement of children should be absolutely prohibited. And our submission, that is at least relevant. It must at least be relevant to the issue before the court. And that's, we say, is a straightforward error in the Court of Appeal. The Court of Appeal found nothing relevant, certainly in terms of hard international provision, when it came to that it considered it required to consider when interpreting Article 3, when trying to read Article 3 in harmony with the international conventions. The soft international law material, Sir James said, well, that significance is, quote, slight. And our submission is that is not how Strasbourg would understand at least the array of soft international law material that you have before you in this case. You have, say, the CPT material, which is something that the Strasbourg Court has repeatedly referred to and relied on. We accept it's not binding. It does have a different role. That has been repeatedly recognised. But that kind of material is certainly not treated as being only of slight weight by the Strasbourg Court. And what would also, we respectfully say, be given significant weight here is just the array of different bodies that have all reached the same conclusion. I won't go through the entire list, but you've seen the array of domestic bodies, international bodies, and it is striking. And they all have a category shift between adults and children, and it's specifically related to solitary confinement. And you can think of the reasons for that when one thinks about how we think children ought to be treated in terms of human interaction, engagement with other people, time out of cell, also the medical risks. And that's led to this whole range of bodies saying acceptable for adults, never acceptable for children. And indeed, the only body that has considered the matter, that has said, well, perhaps in certain circumstances might be acceptable for children, we saw was the CPT report before they visited Cook and Wood. So this was the 2015 one. I won't take you to it again, but it's at 3905 of the electronic bundle, whereas it imposed what in effect is a strict necessity test, but a much higher one. Extremely rare cases, every measure should be taken before you place a child in solitary confinement. So when you have all of those bodies expressing those views, our submission is that something that would certainly be taken into account by the Strasbourg court in deciding whether this treatment was per se degrading, whether it was prima facie degrading, or simply on its factual analysis as to whether it was degrading on the case before it. And our submission is that the lower courts did, we respectfully say, in the approach that they took to it. And as I say, they found the CRC material of no relevance. The CRC, this was the general comment. I won't repeat the submissions I made about the general comments. The court found that the recommendation in relation to the UK in 2016 to immediately remove all children from solitary confinement, prohibit the use in all circumstances, that, it said, was merely a recommendation for future action, not a statement of current law. So James endorsed that approach. Again, we say that is not something that would be accepted by Strasbourg. It wouldn't treat it as irrelevant in that way. And certainly there was no suggestion that weight was given to it. And the reason was that the Court of Appeal understood that as not making a statement of current law, merely a recommendation. But that is precisely how all of this body of soft international material works. And one can see, we respectfully say, the particular error in relation to the CPT report, the Cook and Wood one, which you have at, and you have the Court of Appeals analysis of it and the quote from it at page 210 of the electronic bundle. It's paragraph 98. The Court of Appeal quotes from it. And you see a quote from paragraph 91 of the CPT report. And one of the things Sir James said was, well, here AB was being treated as he was for his own protection, and somehow that, whether that suggests it was a greater justification. But you'll see here that what's being referred to is children, you see in the first paragraph, on a separation list, managed as they were for repeated violence or for their own protection from gang or personal rivalries. Vivid pink sign, then the description, which appears to be identical, almost identical to AB's treatment, say that the then and only lasted for several weeks, and then the conclusion. And what the Court of Appeal said about that is, well, it's just about, it's an assessment of one case. But we saw when we looked at the Ukraine case, it is that kind of thing when it's a fact-finding description of one case, and it's clear the European court gives weight. It's not dispositive, it's not determinative, but it's a fact-finding by a body like the CPT is given weight clearly by the European court when it then decides whether particular treatment, when you have similar treatment being criticised in that way, it would certainly give weight to it in deciding whether it's degrading or not. And all those errors, we say, or those failures to treat the international material in the correct way, and I say it's not, this was, I gave you the CPT example, if one goes through it, you'll see that analysis, the, well, recommendations, not a statement of current law, you see at 96, is repeated, and that essentially is the way in which the various bodies were treated. We say that isn't the correct approach. And once one then, if you like, puts them all in the mix, takes into account in the way required of the international treaties, considers them and considers their relevance and the proper weight to be given to them in relation to the whole range of soft international material, it's clear, we say, that does go to what it means to treat a child in a way that is not degrading. And as I say, whether that takes you to an absolute bar, strict necessity, or something else, maybe for a matter for the court. But we do say, at the very least, what they suggest is one cannot simply import the adult solitary confinement cases and say, well, and we'll also bear in mind this is a child. There was something more going on here in understanding what it means to treat a child with dignity and in a non-degrading way. In relation to the strict necessity argument, what Sir James said is, well, the cases are all about physical restraint. You saw, I gave you the reference to at least the discussion of seclusion in the international materials for patients, which appears to treat them in a similar manner. And we also say that the discussion of the solitary confinement of adults, I say, comes very close to a strict necessity test. But the key submission on that is that what underpins the strict necessity test is a recognition of an interference with dignity of someone who's particularly vulnerable. And our submission is that one can of course see why a restraint has that effect, engages dignity in that way. But our respectful submission is so must 55 days of solitary confinement in this way for a child. In many ways, that is much worse than instantaneous restraint, and is much worse, we say, or at least certainly maybe a much worse experience for a child, but is equally a matter of how we think children in detention ought to be treated. And so that unless one is saying can show there's some exceptional danger, unless one can satisfy a strict necessity test, it will be something that will breach rather than just engage Article 3. Well, so just before 1 o'clock, unless I can assist further, those are my submissions in reply.
Thank you very much, Mr. Squires. Well, we're grateful to all counsel, including those who have been, as it were, sitting behind the people we've heard, for the assistance that's been provided to us. We'll take time now to consider the submissions and issue our decision in due course. The court will now adjourn.